Reimer, do we have all three witnesses,
They're all here, Judge.
including all the way from Oregon?
Yes.
Excellent.
Here with this bag.
Be flying back tonight? That was quick. That's a lot of flying for, oh my gosh. That's a 5-hour flight more there and back to be on the stand for, oh, well.
5 minutes.
That's how the flights are booked.
But he's coming from vacation, so he's in a nice mood. Oh, and you remember all the pictures. Oh.
I agree.
The pictures. It's a problem. Is it her? Was her first picture?
Is he dressed out now?
For tomorrow.
He's dressed for tomorrow?
No, for tomorrow they'll need, so we'll make sure that he's got.
He's good for today?
Yes.
Okay, great. And have you had a chance to talk with him?
Yes.
Okay, so if we can bring Mr. Williams out as soon as he's ready. Surprised Gordon knows how to do that, or is Mr. Williams tying his own tie?
Where is she? This Diana, you look safe.
Oh, yeah, they should have picked that up, Miss, so if you don't mind grabbing, there's some
Absolutely.
evidence that was up there from Mr. John.
Yeah.
No.
Ms. Rivers, are you ready?
Yes, sir.
All right, let's get on the record in State versus Williams. It is Wednesday, almost 1:30. Maybe it is 1:30. We're starting a little late, but drug court ran late. All our jurors are here. Ms. Reimer, anything from the state before we bring the jurors in?
Yes, Your Honor. I did want to just put this on the record, before we get to Miss Stephanie Fowler, who is, the DNA CODIS person. I sent a copy, the redacted copy. It states 15 as well as states 15A. States 15 is the original copy. States 15A is the redacted copy. I've redacted the portion about the offense that we're not discussing for trial. However, there has been a conversation between defense and I regarding the bottom portion, and the state agrees that we should redact the convicted portion out, but not the offender. And the defense, I'll let her speak for herself, but the state's opinion is that if we remove the offender portion, it won't provide a complete sentence. And because we're talking about the DNA match to a person and it's for a sexual assault kit, I believe that keeping offender in would be appropriate.
It would help me if someone could publish, as in share through Zoom rooms, what it is we're talking about so I can see it. The jurors can't because they're not in here,
Thank you.
but Mr. Williams is in here with his lawyers, so we can all see it, and then we can talk a little bit more about what the concerns are. So you would tender 15, it would be made part of the record, but 15A, whatever it ends up looking like, would be what will go back with the jury if that's something that goes back with the jury.
Yes, Your Honor.
Okay. Is Ms. Fowler your first witness?
No, Your Honor.
Okay.
So, Your Honor, this is 15, the unredacted version. What was taken out, if you see the first part where it says East Point Police Department.
Can you magnify it a little bit, please? If you just within, yeah, you go within Adobe. Okay, well, that's plenty big. So this is the unredacted version?
This is the unredacted version.
All right, what are we redacting?
The redaction is from,
Do we have to redact version instead? No, we can just.
So it would be getting rid of all this Tennessee stuff?
this, yes, Your Honor, down to this portion. And we've also redacted where it says convicted offender right here. We
Okay.
redacted that portion,
Okay,
but
so the first one, East Point Police Department, 2006, that's Ms. Jones's case.
yes, Your Honor.
Got it. Then we have a victim from Tennessee. We're not including that. Then we've got this information about Mr. Williams.
Yes.
Okay,
And I took out the convicted offender portion because it doesn't, that part doesn't make a difference because you see that you're speaking about a person. It's this last portion where it says to confirm the convicted offender match. I've taken out convicted but left offender match. And the issue is leaving offender in this complete sentence.
got it. Okay, is there also one that connects Mr. Williams to Ms. Herring's case?
Yes, Your Honor, this is for Ms. Herring's case.
But the
It's just-
2006 case is Ms. Jones's case.
Yes, Your Honor, if you go to the top, sorry. So this is the report for the CODIS match relating to Ms. Cambria's case, but it matched or linked with other cases.
Okay, so the way Ms. Fowler talks about this is here's where we had the hit that linked Mr. Williams to Ms. Herring's situation, the 2014 situation. And it turns out in the larger database, his DNA served up a hit in the 2006 case. Who is going to be able to say that East Point Police Department case 102, et cetera, is Ms. Jones's case?
Miss Fowler.
How is she going to know that?
She also completed the other report, and she knows the victim's name. Not from this report, but based on her records.
The DOFS case number, she will be familiar with it because she did the rape, did something in connection with Ms. Jones's rape kit?
Yes.
Okay, got it. All right, thank you. Who is speaking for the defense? If you could scroll to the very bottom.
Yes, Your Honor.
So I'm going to do this witness, and we're asking for both of those last sentences, starting with to confirm the convicted offender just be removed. I think it is just, I agree with the state that just taking out the word offender makes the sentence kind of clunky and confusing, but I also don't think it's necessary.
What is if we took out everything from DNA data from evidence, so partway up the current screen, if we took out everything from there through the end of this page, I noticed there's a page 2. Let's actually look at page 2 first. Okay. All right. So we have to get rid of that little blurb in that phrase in between the two thick black lines. But if we go back to page 1, tell me the relevance and the probative value of the final paragraph on that page.
Starting with the to confirm.
Yes, ma'am.
Your Honor, that the relevance of that is it goes into Mr. Smith's testimony, which has already happened, and it connects because there is the 3-phase. So you have the DNA typing, the CODIS match, and then
And there's been a whole bunch of testimony about why did you swab this guy? And the reason why is that there was a requirement for a new biological sample from Mr. Williams.
Yes, Your Honor.
Okay. All right. So, Ms. Feely, assuming we're leaving it in, I do find it's relevant. The word convicted is problematic because there's no evidence before the jury that Mr. Williams is a convicted felon. He happens to be that, but that's not relevant to this trial. If we just redact the word convicted, your concern is the word offender?
Yes.
Okay. How do you fix that? We can't type in another word.
I think the solution is just to remove the 2 sentences and have the analysts testify to that. I mean, it's just a bridging of, like, clearly they took another sample. This is just a directive, I guess.
Do you know if Ms. Fowler would say offender is the term we use for the person who comes up with the hit, as opposed to, oh, no, we only use offender if we know this person is guilty?
I would not expect for her to say the last part. I do not know if she will say that offender is the term that we use, but I can ask her. She is outside.
Why don't you ask her that? Because if you will ask her, what does offender mean in this context? It would be the person with whom we had the hit, then I'm okay with you leaving in that bottom part with the word convicted coming out, and then obviously getting rid of all the references to the Tennessee piece.
Okay.
But it really is going to depend on how she would explain the term offender. And the defense would be entitled to ask her that so that the jury isn't left with the impression that there's been any conclusion about culpability. And if her answer is, oh, we use the word offender because it means he's been convicted of something, then it all needs to come out.
Okay.
All right.
Thank you, Your Honor.
While you're out there, was there anything else from the state we needed to cover?
Not until we do the jury charges again.
Okay. All right. Ms. Wood, other than the discussion we're having about redactions to states 15, anything from the defense?
We don't
or Ms. Feely?
litigate this now, but there was a jail call that we received today that was from last night, that's between Mr. Williams and his mom, who's also present. So we would like to address that. I know we're needing to get the jury in here, so we don't have to do it right now, but.
Okay, but just preview for me, you've litigated jail calls before. I have. They say this is not a private call, this is being recorded, et cetera. And Mr. Williams's mom is not his lawyer. So preview for me any possible objection. And it's not late disclosed because it was a call made last night. Maybe it's not relevant, and then it's the contents that I'll need to worry about. But procedurally, what would your objection be?
So we do have, I can restart my computer, so I'm pulling it up now. The case is Davis versus the state. It's a 2020 decision for Georgia, 307, Georgia, 625. And it is basically, I guess before we get to that, just as a policy point of view, he should be treated like a litigant who's not in jail. And we dress him out, we make sure that the jury doesn't know that. So from jump, that is also obviously a jail call, and that will bring all the prejudice that brings. The second part, though, is that he should have the equal protection and due process that a non-inmate litigant would have, which would be being able to speak with his family about this life plus trial that he's having. So the fact that the Davis case talks about whether it's for the purposes of security at the jail, that kind of thing, this was clearly for the prosecution to use against him. And so I think that's where the Davis case points out that that's different.
Okay, I'll read it. I don't want us to argue it a whole lot now. I just was curious if there was something. You're up against the stacks of case law that say this is coming in if it's relevant. But if there could have been something unique about it, where in fact, Mr. Williams's mom is part of the legal team, or he used a cell phone instead of the jail call or something like that. But this is a heartland jail call. All the policy arguments you made are understandable and have been assessed by courts around the country. I will look at Davis and we will revisit this. Have you had a chance to listen to the call?
Yes, I have listened, I want to listen to it again, but yes, I did get it.
Okay, but in the initial run through, your objection is not relevance. It is due process, privacy, all the grounds that you might raise if you were trying to litigate once again in front of the Supreme Court or the Court of Appeals, why jail calls shouldn't be admissible. Okay. All right. I will take a look at the Davis case. Anything else from the defense? All right. What did you learn, Ms. Robinson?
So when I asked Ms. Fowler the question of what offender meant, her initial answer, and what I believe she would say on the stand, is that it comes from the CODIS database, which means that he is a convicted offender. So the state will agree and take that portion out.
Okay. So it sounds like Ms. Fowler's not your first witness, so there's time to edit it. And really anything about Tennessee is out, and then it spills over to the second page, just that sentence, because offender to Ms. Fowler means, yeah, it's a convicted offender. That's not necessarily why he's in the database, but that's how she would translate it if asked. Okay, thank you for asking.
Thank you, Your Honor.
Were there other concerns, Ms. Feely, about states 15A? If they take out everything about Tennessee and then I think it's only maybe two sentences, but that final paragraph that spills over to page 2, if that's out, the other stuff's coming in. Okay. Thank you, Ms. Robinson, for being thorough with that.
Thank you.
Let's bring the jury in, please.
And you're ready.
Rise for the jury.
All two is accounted for.
Thank you. Everyone can be seated. Apparently Deputy Gordon got demoted. Not even handling the jury anymore. Yikes. Happy Wednesday afternoon, everyone. Thank you for being on time. Drug court ran a little late. We had some participants who struggling even more so with addiction than others. And then there were a couple legal issues that came up with this case that we had to work through while you were sitting back there. So I apologize for the delay, but it was about 80% us working on your case, just things we had to talk about outside your presence. Ms. Reimer assures me that all the state's witnesses are now here and that we can continue on with the state's case. And there is still very much a forecast that the state will rest at some point this afternoon. So we're still in the state's case. Ms. Reimer, if you would call the state's next witness.
Yes, Sean. State calls Ms. Annie Whitmore.
Good
Raise
afternoon.
your right hand. You swear affirm that the testimony you will give be truth, the whole truth, and nothing but truth, self God.
I do, yes.
Brilliant, I'll see. Can you state and spell your name?
Thought it was on wheels, my bad.
No wheels.
Yes, it's Anique Whitmore, Anique Whitmore.
Good afternoon, Ms. Whitmore.
Good
How are you?
afternoon. I'm making it.
I'm here with that. How are you currently employed?
So I am in private practice as a psychotherapist at Buckhead, psychological associate with Buckhead, excuse me. And I have been practicing for over 20, almost 25 years.
And in that practice, what does that work involve?
So I see a multitude of clients ranging from little itty bitties to 60, 70-year-olds. Whenever individuals are facing some sort of adversity in life or recovering from a traumatic event, I see individual therapy, I do group therapy at times. And a large portion of my practice, I consult on various types of cases, such as child sexual abuse, rape, stalking cases, witnesses to major crimes. And also part of that is that I teach in the area of forensics and sexual abuse and trauma.
Okay. And prior to going out on your own practice, where did you work?
So prior to leaving opening my practice fully, I was actually an employee here at the Fulton County District Attorney's Office as their Director of Forensic Services. There I specialized in a unit called Crimes Against Women and Children. And in that unit, we specialized in, the attorneys prosecuted cases that involved the vulnerable population, the elderly, as well as exploited children, trafficked individuals, those have been raped, molested, stalked, partner abuse. And part of my responsibility in that unit was not only to help the attorneys understand the dynamics of trauma and how our brains work when we have been abused, but to work with the reported victims as well as review cases that have come in from local jurisdictions to better understand what we have. And then with my expertise and background, to recommend to the district attorney at the time whether to pursue this case or if there needs to be more information sought.
And then prior to the Fulton County District Attorney's Office, where did you work?
Yep. So I was the director, executive director of Harbor House, which it was is a child advocacy center that covers all of Northwest Georgia. There I conducted forensic interviews, evaluations, extended interviews, of course, supervised the clinical staff and taught multidisciplinary teams the dynamics of abuse. And then prior to there, I was the program manager for the Fulton County, the Georgia Center for Child Advocacy, which covered all of Fulton and DeKalb County, which was similar in duties, where I supervised the clinical staff, conducted interviews myself, trained FBI, GBI, law enforcement, other forensic specialists. I think that is where, and then, yes, and then, of course, I think I said it, conducted my own forensic interviews also.
And how long were you with the Georgia Center for Child Advocacy?
I want to say it was about 5 years, 6 years.
And can you please tell us what your educational background is?
Sure. So I have my undergraduate and graduate degree from Northwestern University in Illinois. My undergraduate was from the School of Education Social Policy, minoring in psychology. And my graduate degree is also in counseling psychology. I'm a licensed professional counselor, licensed here in Georgia. I took my boards in early 2000s.
Okay. And about how many victims of sexual assault have you worked with?
Unfortunately, thousands. I have forensically interviewed in an ongoing investigation over 900 forensic interviews. I have supervised probably triple that, and have again consulted in both on the prosecution side as well as the defense side in regards to really just assessing what the case entails.
And of those victims of sexual assault, have any been adults?
Yes. I don't know the percentage, but definitely a large percentage. I have, of course, interviewed children as young as 3, 4. And technically in the state of Georgia, we forensically interview individuals from the ages of 3 to 17. And then past that, they're considered adults. But there are many occasions in which I will be asked to interview adults of sex crimes.
And about how many individuals have you worked with that have experienced some kind of trauma?
I would say the majority. So in my private practice, for a long bit of time, that was my focus. For my own personal reasons, it's just healthier for me emotionally to really balance out that population with other types of traumas in life, children growing up and perhaps experiencing divorced parents, and in a contested divorce, perhaps. But the majority of clients that I have worked with have been trauma related.
And have you ever testified or qualified as an expert before in court?
I have, yes.
About how many times?
To date, it's approximately 65 cases.
Okay. And have you previously been qualified as an expert in trauma, sexual assault, the impact of trauma on a victim of sexual assault?
I have, yes.
And Your Honor, at this time, I would tender Ms. Whitmore as an expert in trauma, sexual assault, and the impact of sexual assault on victims of sexual assault.
We wouldn't object to that. As to, may I inquire what role that this witness has in this case? Because I think we have a relevance objection as well.
So we've talked about this some outside the jury's presence and probably outside your presence. And I've already worked through relevance. So but you're objecting, so denied as to, or overruled as to objection number 2. But objection 1, you're objecting to having Ms. Whitmore qualified? As in you don't believe she's qualified, or you don't think that trauma is relevant to the case?
I'll review her.
Okay.
She's an expert purportedly of trauma, sex assault, and.
So I'm not quite sure I don't know how many commas were in what Ms. Reimer said. I was taking it to mean, in general, an expert in the field of trauma that is caused by sexual assault, how it manifests itself, etc. But to me, that's subsumed by the number of words that Ms. Reimer used. But why don't you maybe more carefully designate what it is you seek to designate Ms. Whitmore as an expert?
Yes. The impact of trauma on victims of sexual assault.
Okay.
Mayor, review her.
You may. And ladies and gentlemen, you heard the phrase voir dire before. That was what you went through last Wednesday. This is different. We use the same term, but it's basically an opportunity for the opposing side to explore with a potential expert her qualifications or lack of qualifications, so that then Ms. Feely could argue, should she choose to, say, well, now that we've learned this, I think you should not find Ms. Whitmore to be an expert in this area that the state is seeking. Ms. Feely.
Thank you. If I heard correctly, you don't have a doctorate degree, is that right?
That's correct.
And then tell me again what your professional licensures are,
I have an LPC, a licensed professional counselor.
and that's here in Georgia?
That's correct.
You haven't spoken at any conferences or anything like that, right?
I have, yes. I speak across the country and internationally for the federal government. I am a instructor for Child First that covers forensic specialists across the country. That's I work with the armed forces, have testified for them in court martials, as well as teach for them in DC and Virginia. And I've been teaching since 2002, when the governor at that time asked 7 of us to teach those who specialize in this area in Georgia on the dynamics of sexual abuse.
I just clarified something else, and based on that, I don't have any other questions on.
With the clarification.
Right.
Okay. So you had objected, one, to qualifying Ms. Whitmore at all in what we're now going to call the field of the trauma of sexual assault, the impact of trauma
Yes.
on sexual assault victims.
Yes, sir.
But you also objected on relevance grounds. I've addressed the relevance objection. I'm overruling that. Having learned what you've learned, and you may have gotten an extra snippet from Ms. Reimer, are you withdrawing your challenge? I'll call credentials challenge?
Sure.
Okay, all right. Ms. Whitmore, I'm designating you an expert for the purposes of this trial in the field of the impact of trauma on victims of sexual assault.
Thank you.
In your experience, what kind of emotional responses do you see in victims of sexual assault?
So I see a wide range of dynamics and responses to it. Of course, depends upon your age and your level of understanding of what you just endured. It depends on one's personality and their support system, their relationship to their offender. What is known in this area of expertise is victims oftentimes know their offender. We oftentimes in the press or in the news, we sometimes hear about stranger danger, or we teach our kids that. And does that happen? Of course. But it is more likely than not that individuals know their assailant, whether that be a loved one, a former or ex-girlfriend or boyfriend, a pastor, a coach, a neighbor, significant others of some sort. So the dynamic of how you respond to that assault can range from having a very flat affect because you're still in shock, you're still kind of in that mode of what just happened, to someone who is much more emotional and unable to speak details of what they endured because it is just too still raw with them, to them. They don't know how to process it. And so in my career, I've seen it from day one of reporting abuse to 3 years down the line in therapy with me. And I will see a wide range of emotion.
And in your experience, is that the same kind of response when it's a stranger involved sexual assault?
It is. It depends on whether or not you understand what you just endured, right? A lot of times what is factual based on literature research, my professional experience with thousands of victims, is that you are only able to process so much in a short amount of time. So the longer you are removed from the actual act of abuse, the actual more details will resonate in your story and your ability to speak, whether that be someone familiar with you, to you, or a stranger.
And you used the term earlier, a flat affect. What does that mean?
So a flat affect is is how one emotes their energy or their verbiage or what they say, their disclosure. It's a statement without inflections. And so it sounds very almost rehearsed with not a lot of emotion. And so someone doesn't have a trained ear or eye in this area might look at someone's disclosure that there is no emotion or urgency in their disclosure as, did this really happen? How much were they emotionally affected by this because their affect was so flat? There was no ups, there was no downs. And so we as specialists have to really look at what they're saying and compare it, corroborate it to various other statements, various other bits of information and evidence.
And have you experienced victims with flat affect of sexual assault?
I have actually more so than not. Again, I have been in some of the victims' lives early on and some years later. But what remains consistent is the amount of times that victims have to share what they've experienced. And so over time, that becomes very rehearsed, not in a negative way, like I have to memorize what happened, but it's like any other sort of trauma that humans experience. And that goes for, excuse me, incidences in which you or I maybe have experienced something that was traumatic, someone diagnosed with cancer, and you speak about it in the first week of finding out, and it's very emotional for you. But the more you discuss it and the more you understand that that person may be okay after treatment, the more you're able to speak about it with a more flat affect or more of a general sense of factual statements versus introducing your emotion to it.
And is it common for adults to be able to talk about this without becoming emotional?
It depends on who you are and your personality and your level of stability. And if you have gotten any sort of intervention with treatment, right, to better not understand why it happened to you, because no one understands, reportedly, allegedly horrible incidences, but you become at a place within your life that you're able to express it in a more expressive, linear fashion.
So then how common is it to become emotional when speaking about this?
So it depends on how far you are away from the actual act of crime. If you experience it day one and you're speaking about it 10 days later, that's one. But oftentimes over time, you begin to heal from the trauma. And when you are forced to speak about it, it's like ripping a scab off or ripping that Band-Aid off and having to go right there. Especially in environments like this, when you have a bunch of strangers looking at you, the person that you're accusing did this to you is looking at you, and you're feeling judged, and it's a very raw emotion. So emotions oftentimes will come flooding out, and victims don't know how to process that in the moment or push it back down like they've had to do perhaps for previous years.
And how common is it, excuse me, for victims of sexual assault to feel guilt over what happened?
It's one of the most common feelings and responses to being a victim of sexual assault. They oftentimes feel guilt, responsibility, the what if I wasn't in this place at this time? What if I would have dressed differently? What if I would have said something? What if I, kicked, screamed, ran? What if this conversation I didn't entertain? And at that, in my work with these victims, recovering victims, survivors of assault, that's one of the biggest pieces of work that I do in my practice, is working with that sense of guilt and what could I have done differently? And helping those individuals understand that when you are abused, taken advantage of, assaulted, you are oftentimes completely out of control of what is occurring to you. And so it's that understanding of guilt is not necessarily an emotion that you should receive as your truth.
And so what's the impact of that feeling on their response?
Yeah. So in those moments of feeling guilty, they tend to refrain from disclosing and talking about it in detail, worried that people aren't going to believe them, worried that they are going to sound like they wanted this to happen. Some victims worry about their history coming in. Not all of us live a perfect life. And so they're concerned about judgment and how they're going to be looked at. Are they going to be looked at as damaged goods? How are they ever going to entertain a future relationship? Their level of trust in society and the world around them, their environment becomes jogged and questioned. It plays a part in daily functioning from there on out.
Can you please tell us how memory can be affected by this trauma?
Sure. So without going into a 30-hour presentation, which I do at times, our minds are magical. We have different categories and sections of our mind, and we've all had experiences in which we try to push those memories out of our forefront, right? We try to push them into the back of our brain. And only with a special lock or key can we unlock those memories. So what trauma does is it puts it into a place in our mind in which we safekeep it. We cover it up, and without specific questions and with the trained question of bringing those memories back out, they at times you will lose the significance of those contextual details. Memories are such that we recall as victims what is important to us. We store what those memories are within our own brain. So if someone's asking you, what did they wear, or what color hat or socks, that may not be important to you, but what is important to you is what happened to your body. Those core details are oftentimes just what I call the core of an onion. The layers sometimes are not of as importance, but the core of what you experienced, of where you were, what happened to you is important. Sometimes the smell of people resonates to you in your memory. Sometimes what was said or what was threatened to you is retained in your memory.
Bless you.
I recall working with this one client in which she was unable to eat fried foods or go into restaurants that had fried food because her assailant worked at McDonald's. And so that smell and the clothing of fried food. So whenever she would smell that, it would trigger her and bring her back to those moments in which she was raped. So our memory is magical, sometimes for the good and sometimes for the bad when it comes to investigations, right? Some of those details we want to and need to know, but we don't always store those in our memory.
You mentioned contextual details. Can you explain more about that?
Sure. So contextual details are the who, what, where, why of something. Not necessarily why, because we don't know why things happen, but it's the who, describing what happened to you. It's what happened before, what happened after. What did you say? What were you unable to say? What stopped you from telling right away? What stopped you from yelling and screaming in the moment and yelling and calling 911? What stopped you from telling the on-call officer all of the details? What changed over the course of 10 days or a year that allowed you and encouraged you to share with everyone what you experienced? And so it's those details that experts in the area look for to really help corroborate and to understand what that individual is experiencing.
And again, in your experience, do those who are sexually assaulted remember every detail?
They don't. And as a therapist, as a psychotherapist, I'm actually glad they don't, because sometimes those details send you into spiral state, right? They can cause eating disorders, just mental health deficits, emotional struggles, difficulty having intimate relationships in the future. So it is oftentimes common that the details of their offense are oftentimes forgotten. And I always, as a professional, will ask, when I'm in an investigatorial, when I have that hat on, I ask them, do you not remember or do you not want to speak about it? And it's oftentimes the latter, because when speaking about those details, it's oftentimes very visual, and it's very wrenching to them, and it sets them back in their recovery and in their ability to process what they've experienced.
Are all disclosures the same?
They are not. I, of course, like I said, I've forensically interviewed almost 1,000 victims. And although some of their experience was similar, I have yet to interview someone who has been identical to another. And that's because we are human. We are individuals who experience life differently, have different support systems, are mature, some are immature, some have been exposed to past traumas, some are more savvy, some are less savvy. Some are more introverted and some are more extroverted. So everyone experiences trauma in different ways.
Who do victims of sexual assault typically make a disclosure to?
So oftentimes it's not necessarily those who love them the most and that perhaps could show them the most support because they're worried about judgment. They're worried about, are they going to be believed? They're worried about, am I always going to be looked at differently? So oftentimes it's people like me. It's in the forensic role or the therapist or law enforcement because they can say it and go away. They can write a statement and leave it there. They oftentimes don't tell details to their significant others. I can list dozens of clients of mine who have yet to share with those that they love the most, perhaps their partner, their husband, their wife, their children, what they've endured in life, because it's just their privacy, their private nature. And it's oftentimes difficult to speak about those details.
Are there times where the initial disclosure is made to a loved one?
Absolutely. And it depends on that relationship with that loved one. Oftentimes victims will look to that loved one at times to look for guidance. What should I do? Who should I tell? Should I call the police? What do I do? How to help me through this process?
Does trauma always appear immediately?
It does not, no.
And how long could it take a time to settle?
Absolutely. So there's research that shows oftentimes as a forensic specialist, we shouldn't approach victims until 72 hours after the act of crime. And part of that reason is because without getting into all the details of what our brain does and medically, but the adrenaline in our brain, the fluid in our brain, we are on high alert within 72 hours of a crime. And so things are a blur. But after 72 hours medically, you become more settled and you are able to speak about whatever you experienced in more of a third person situation so that you can almost separate your intense emotions of the event and speak about it in a more calm way. And it's in those calm moments, you're able to recall some of those details that the investigatory party may be looking for.
Is there sometimes the opposite reaction?
There is. That's why, so it conflicts with each other, right? So forensically speaking, when I'm working with children who have been abused, we want to interview them soon after the event so that we can get those utterances and those bits of information that we as professionals will be able to piece together afterwards. Again, it's case by case specific, excuse me. But it is oftentimes known medically, 72 hours later is a little bit better. But the immediate outcry, there's oftentimes still valuable information that can be sought.
Can you please tell us in your experience what society expects of a victim of sexual assault?
Oh, sure. Easy. So the myths of sexual assault is that it happens and you run and call 911 and you immediately tell. Does that happen? It does. It is actually more rare than not. It takes time to accept what has occurred to you, know what to do with it, and then take action. So again, it's case by case, but what society and the layperson would assume, and I too, before getting into this field, is to assume that an immediate outcry is to take place. Many people think they know what they would do, but until you're in that moment, and what evidence will show is that delayed disclosure is one of the most common. It's actually 72% of the time that your disclosure is delayed in acts of crime.
Do victims of sexual abuse trauma ever block anything out from a sexual assault?
Absolutely. It's in my experience that the majority of the time something is blocked out because you experience it as too difficult to absorb, too difficult to accept that it's happened to you. Your boundaries have been 100% crossed and you don't know how to move forward. And so you purposefully and subconsciously block some of those traumas out, such as what was said, was there a gun involved? Was your head shoved in the pillow? Were you knocked upside the head? And until you are shown perhaps photos of a black eye or trauma to your body in some way, will you remember some of that information?
On the flip side, are there ever any details that are constant to a victim?
It depends on what you store in your memory, right? What you deem as important or what you experience as important. If I'm a victim and I think that the sex of that individual, if it's a male or a female, if they were speaking English or non-English speaking, if they had pink socks on and a backwards hat, if I deem those as important to me, I'm going to put those into my memory. If I don't think those are important, those aren't going to be details in which I'm going to easily be able to recall.
Have you ever encountered victims of sexual assault who just want to move on?
Absolutely. That is why part of my job I don't like, and part of my job is when I do clinical assessments of reported victims months or years past the alleged offense, and I'm in there peeling off that Band-Aid or taking that scab off because they just want to move on with life. And when I am working with various jurisdictions and different court appearances across the country, that's one of the things that I find to be most difficult when I'm working personally with the victims is encouraging them to tell their story because they have wanted to move on for months and years.
And can you please just elaborate a little more about a victim who experiences something traumatic and then years later it has to remember it again?
Sure. So unfortunately, in our systems across the country, when abuse occurs, our system at times takes time. So you may be facing trauma because you've experienced it day one. But once it gets the system, gets through, law enforcement, they do their investigation, it gets presented to a given district attorney's office or a juvenile court. By the time it gets indicted, by the time it gets on a trial calendar, and by the time it gets called, you may be looking at 2, 3, 4 years down the line. Some cold cases in which I've worked, it's 10, 15, 20 years down the line. So you are a victim at 15 and all of a sudden you're 30 years old and it's a completely different time of your life. You're married, perhaps have kids, or in graduate school, and you're having to come speak about one of the most horrific times in your life. It becomes very difficult to make your brain go there and to emotionally go there.
And can you explain what the range of emotions you've experienced with victims of sexual assault?
Sure. Like years later or within the moment?
I would say, let's start within the moment.
In the moment, oftentimes it's shock and fear. And we all function differently out of shock and fear. Some of us freeze, some of us go erratic, right? And spill out and look for immediate help. Some become very recluse. Some become extremely vigilant and determined to seek justice. Some hide and not sure when they're going to come out, right? They go into a state of depression and unable to help themselves. You go from that extreme to the complete other extreme of working with individuals years down the line and angry with me and avoidant because they don't want to speak about it. They don't want to go there because they were emotionally extremely unhealthy. Turning to drugs, alcohol, eating disorders, self-harm, cutting themselves off from loved ones, from their support system, breaking off relationships because being intimate is much just too difficult. And not just physically, sexually intimate, but intimate in regards to sharing who they are and allowing people in their inner circle.
Is there a right way to respond emotionally?
Absolutely not, no. Is there a perfect way? No. Is there a right way? There is not. Investigatorial wise, we wish there was a perfect way because it could make certain folks' jobs easier. But we're dealing with human behavior and dynamics and interaction. So we as humans are imperfect, and our emotions and responses to trauma is imperfect.
You never met with Miss Kimberly Herring or Miss Lucinda Jones, right?
Not to my knowledge, no, I did not.
And but you had the opportunity to review the case files?
I did. And I say not to my knowledge. I have been involved in many cases. And so if their name or something came across my desk at some point, but I do not recall that. But this particular case, I did not interview them, no.
Did you have the opportunity to review their case files?
I did, yes.
Okay. Can you please tell me about the emotional response of Miss Herring in this case?
Sure. So in this file, their response initially was more of that flat affect in which I spoke about, in which there was a time in which, the facts were just laid out there. And to be fair, I think the viewer would see that as, what's going on? You're saying this so matter of fact, right? And how do I perceive this? But as the file will show and demonstrate that it was after time in which when life settled, there was much more emotion and realization of what that individual just endured, and then additional help was sought.
And is that something typical you would see in your experience with sexual assault victims?
I have definitely seen that over and over again, yes.
How about Miss Jones? Did you have the opportunity to review her file?
I did, yes.
Can you please tell us about the response of her in this case?
Yeah, and so there's similarities and differences, right? And again, we're human, we're all different, we're all unique. And there's emotion, and so part of my job and my training is to really look at language and emotion and body language. And when I see that there is a disconnect between the three, that's when my red flag goes up, and there's more questions and more investigation on my end of things in which I want to learn and understand the dynamics of it all. And so I saw that with her, in which I want to know more, right? Are these questions going to be answered? And again, reading the file and the discovery, I was able to really understand her experience.
And is that typical of someone who's experienced a sexual assault?
It is, yes.
And both of them, can you speak about the contextual details they recounted in their files?
Yes, and so you speak about the who, the where, what was going on, what was happening before, what happened after, what they were saying, what happened to their body, what areas on their body was touched, what they were allowed to do, what they were not allowed to do, their inability to immediately, to escape that moment, how it felt days and weeks after. Where they went, how they carried themselves, what they thought what they needed to do, what they had ingested, how they felt, because of different influences, their relationships with with the accused. Each spoke about what they've experienced, what I would consider developmentally appropriate based on their age and who they are as an individual. I oftentimes will speak about consistencies or inconsistencies. And so developmentally, based on what they've experienced, they were appropriately responding in that dynamic.
So going back to Miss Herring, in the file, it mentions the smell of someone. Can you please talk about that, her response to that?
Yes. So there were a lack of contextual details in certain areas, but when it comes to memory, right, what she stored in her memory, the smell of beer or that smell of alcohol, I believe it was on his breath in which she smelled it. And for her, that was something that retained a memory for her, which remains consistent with the other reported victim, right, in that too was present in her story and in her disclosure.
And then for Miss Herring, she had a breakdown a couple days later. Can you please talk about that?
Yeah. So Ms. Herring, that's when I speak about how when things settle in our brain and in our body, and what we are then able to speak about in detail, in context of that feeling of being outside your body and needing to feel cared for and to be understood and to be heard and to seek that help that one seeks.
One moment, Your Honor. I have no further questions. Thank you.
You're welcome.
Ms. Feely, do you have questions for Ms. Whitmore?
Thank you, Your Honor. You said you didn't interview anybody in the case this jury's here to decide?
That's correct.
I don't have anything for everyone.
Any redirect?
No, Your Honor.
Any questions from the jurors? All right, Ms. Whitmore, thank you so much. Appreciate your time.
Thank you. Excuse
See
my voice.
It's all right. You were audible. State's next witness.
Yes, Your Honor. The state calls Alan Bradford Dixon. The two. So is that 6 and 9? Sorry. Okay, thank you.
Please raise your right hand for all participants. Do you swear affirm that testimony you'll give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You know, you got to see. Can you state and spell your name for the record?
My name is Alan, Alan, Dixon, Dixon.
Good afternoon, Mr. Dixon.
Good afternoon.
Where are you currently employed?
I'm employed by the Washington State Patrol, Vancouver Crime Laboratory in the state of Washington.
What is your position there?
I am a supervising forensic scientist.
And what do you do there as a supervising forensic scientist?
I manage the day-to-day activities of the DNA unit at the laboratory and also perform DNA casework at the laboratory.
And how long have you been there?
About 11 years.
And before that, where were you employed?
I was employed directly before that at the Santa Clara County Crime Laboratory. That's in San Jose, California. Prior to that, I was at the Oakland Police Department Crime Laboratory, also in the DNA section. Prior to that, I was also at a private company called Applied Biosystems, which manufactures many of the forensic DNA testing products. Excuse me?
The name of the company.
Applied Biosystems, which manufactures many of the forensic DNA testing products used in the United States and worldwide. And then prior to that, I was at the Georgia Bureau of Investigation Division of Forensic Sciences in the biology section.
How long were you at the Georgia Bureau of Investigations?
3 years.
And what was your position there?
I was a crime lab scientist.
What was your responsibility as a crime lab scientist?
I performed DNA analysis at the laboratory.
Were you employed there in 2006, 2007?
Yes, I was.
And can you please tell us about your educational background?
I have a bachelor's of science with a major in biology from the University of Georgia. And I also have a master's of science in forensic science from the University of Alabama at Birmingham.
Have you previously testified as an expert in the area of DNA analysis?
Yes, I have.
About how many times?
About 75.
And where were those testimonies?
Throughout the state of Georgia, in California, and Washington.
Do you know about how many were in the state of Georgia that were in Fulton County?
No, I don't.
And Your Honor, at this point, I would tender Mr. Dixon as an expert in the field of forensic biology.
Okay, then Mr. Dixon, we're qualifying you as an expert in the field of, you said DNA,
Analysis.
forensic DNA analysis.
Yes,
Okay,
Mr. Dixon, did you work on a case involving Lucinda Jones?
Yes, I did.
And I'm sorry, and J. Scott Williams?
Yes.
And what was the first analysis you requested to do on that case?
The first analysis was called a male DNA screening, and it's a process of DNA analysis where it is a screening for the presence or the absence of the Y chromosome, which is present in biological males.
And why would that kind of exam be requested?
That would be requested to determine if there's any foreign DNA present, typically when there's a female involved.
And can you please tell us how that analysis is performed?
Yes, the first process is to break open, take up a tiny portion of a sample. Usually it's from a swab that's been collected from an individual. The cells on that swab are broken open, and then they're quantitated or found out how much DNA is present in that particular sample. And one of the targets that is looked for is of the Y chromosome. So if it's positive for the Y chromosome, that means male DNA is present. If it was negative, that means that no male DNA was detected.
And did you author a report in this case?
Yes, I did.
I'm showing what I've previously showed defense, and previously been marked as states exhibit 20. Do you recognize this?
Yes, I do.
How do you recognize it?
This is a crime lab, the official report that I authored.
And is it appear to be the same as when you authored it?
Yes, it does.
Your Honor, at this time I move in what's been previously marked as states 28 evidence.
Okay, Ms. Feely, any objection to states 28?
No.
It's admitted.
Did you have another analysis that was requested?
Yes, I did.
And what was that called?
That would be the standard DNA analysis testing after the male screening.
And why is that performed after the male screening?
Because this particular test was positive for the presence of male DNA, then it proceeded on to the full DNA analysis testing.
And can you please explain how that analysis is performed?
It's similar to this analysis where for the presence of the Y chromosome, where the DNA is extracted and it's quantified, but then it goes 2 steps further where it amplifies the DNA or makes many, many copies of specific areas of the DNA, which in turn is the DNA profile of that particular sample.
And did you also author a report in this case?
Yes, I did.
I'm showing you what's been previously shown to defense and marked as states 30. Do you recognize this?
Yes, I do.
And how do you recognize it?
This is the official report from the crime lab of the additional analysis.
Does it appear to be the same condition or the same as the one you authored?
Yes, it does.
Your Honor, I'd move into evidence states 30.
Ms. Feely, any objection to states 30?
No.
It's admitted.
Can you please tell us what was tested in that exam for that analysis?
A swabbing which was collected from the right thigh was tested.
And what did the test result in?
The first test was positive for the presence of human male DNA. Then when I did the full DNA analysis, with a reasonable scientific certainty, it was concluded that the DNA obtained from the right thigh swab, which matches Jai Williams, originated from him or his identical sibling.
And how did you get the sample that was to Jai Williams?
That was a DNA reference sample submitted for that individual.
Showing you what's previously marked as states 29 and entered as states 29? You recognize that?
Yes.
How do you recognize it?
This is the GBI crime lab case number and barcode on it, as well as my initials and the date of analysis or sealing of the evidence.
And what is the initials indicate?
This was my initials where I put my tape seal on the evidence once I was done with my testing.
And did you also test the sexual assault kit in this case?
Yes, I did.
Which is I'm showing this in previously marked as states 27 and 27A. Do you recognize this? Can I open the envelope, Your Honor?
It's your envelope.
27A.
Yes, I recognize it.
How do you recognize it?
Similarly, it's got the GBI case number and barcode on it, as well as my initials and date, and tape seals are present on the item.
And what is it?
This is a sexual assault evidence collection kit, and it was identified as collected from Lucinda Jones.
And does it appear to be in the same condition as when you tested?
Aside from this item not being attached to it anymore, yes, it does.
And for the record, the item that is not attached to it anymore is what?
It's a name tag.
Okay, something adhesive that is no longer adhering to the envelope.
Correct.
Okay.
And what is the information on that?
That's a name as well as some other information, a barcode.
What is it, your name or Ms.
It's
Jones's?
Lucinda Jones's name.
Okay.
Your Honor, at this time, I move to evidence states 27 and 27A.
27 and 27A are admitted.
Okay, so you tested the known vehicles in this case?
That's correct.
And what were the results?
The known vehicles both produced DNA profiles.
And who did they match?
Well, they were submitted for an individual, so that's what they're assumed to have come from.
And who were those individuals?
Lucinda Jones and Jai Williams.
I have no further questions. Thank you.
Feely, do you have questions for Mr. Dixon?
Do you still have states 28 and 30 in front of you, sir?
I left everything there.
Yes.
On states 28, I believe that's the report dated 2007. Is that right? Top right.
28 is 2006.
Okay. So in this particular report, you noted that the seal placed on the evidence was not initial. Is that right?
That would be noted by the evidence section upon receipt.
And somebody in your laboratory did in fact seal and initial it to meet the accreditation standards, right?
It was sealed, but the description says it was sealed, but it was not initialed. So then it was subsequently initialed by laboratory staff.
And can you tell the jury why these protocols are in place about sealing things and initialing them?
That's to have tamper evidence seals on the items to show that hasn't been opened prior to being received.
Thank you. That's all I have.
Ms. Reimer, any follow-up for Mr. Dixon?
Just one. The hit was sealed, still sealed when you received it, correct?
Yes.
No further questions.
Jurors, questions for Mr. Dixon? Oh, okay. Quiet jury today. Mr. Dixon, appreciate all your travels. You are free to go. So before you call your next witness, someone should, I don't want 27A to fly away. So you could gather all that. And your next witness is?
Your Honor, state calls Ms. Stephanie Fowler.
Raise your right hand. Do you swear affirm that the testimony you will give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Go ahead and speak. State and spell your name for the record.
My name is Stephanie Fowler, and that's STEPHANIEFOWLER.
Good afternoon, Ms. Fowler.
Hi.
What's your current occupation?
I am a forensic scientist. I work for the Georgia Bureau of Investigation in the Division of Forensic Sciences, and I am currently an assistant manager in our forensic biology section.
Okay. And how long have you been an assistant manager in the biology section?
I think I've been an assistant manager for about 14 years, but I have a total of 21 years with the Bureau.
So what's your role in that?
So as an assistant manager, it is my position to help our scientists perform the work that they need to do. I'm doing such things as assigning cases, answering their questions, approving leave, signing timesheets, things like that that a manager would do. I'm also a fully trained DNA scientist, so I am still proficient in DNA testing methods. And I'm also the administrator of our state DNA database.
Okay. How long have you been the administrator of the local DNA database?
I've been the administrator since 2009.
2009. Okay. So What is a database administrator?
My functions for the database is to ensure that we are using this database as outlined by state and federal laws and guidelines that are set forth by the FBI. So it's my responsibility to ensure that only those individuals who have proper training and clearance have access to this database, and that the DNA profiles that are entered into the database meet all of the guidelines that have been put into place.
What's your education?
I have a Bachelor of Science degree, and I also have a Master of Science in Forensic Science.
And what type of training do you have to do the work that you do?
My training has actually started back in 1993 in grad school. I did work for the Alabama Department of Forensic Sciences before I moved here, and I started my DNA training with that laboratory. And then once I moved to Georgia, I had training in-house in the DNA testing methods that are actually still employed at the crime lab. And so throughout my career, I have maintained this proficiency in this testing by attending conferences, taking tests on a regular basis, and staying abreast of the new technology as it comes online.
Do you have any specialized training to be a database administrator?
Yes. So when I was appointed as the database administrator, I did spend a week in outside of the FBI laboratory where they had individuals that came to a training facility and gave us training on how to use this database.
Have you ever testified before?
Yes, I've testified only in the state of Georgia, and it's been anywhere from 80 to 90 times.
Ever been tendered as an expert?
Yes, in all of those.
And Your Honor, the state moves to tender Ms. Fowler as an expert in DNA analysis.
All right, Ms. Fowler, for the purposes of this trial, you are deemed to be an expert in the field of DNA analysis.
Hey, Ms. Fowler, you said that you were over the DNA database. Can you tell the jury about how this works?
Yes, so this DNA database, it's just a large computer. It has a server that houses this DNA data. And as you've probably already heard, the DNA profiles are just a series of numbers. And so for the cases that we work in the state of Georgia, we put in those DNA profiles into this database, along with individuals that are required to provide their DNA. And then we take all of this DNA and we use the computer software to tell the system to do comparisons between each of the cases and each of the individuals to see if there are any matches in that DNA data. And so again, that's part of my duty, is to initiate those searches on a weekly basis and then look at any possible matches to determine if indeed these cases do actually match each other, or if the cases match to individuals, and then issue reports on those potential matches.
Excuse me. And so this is something that you do on a weekly basis, you said?
As far as doing searches, yes, we usually do that about once a week. It really depends on how many new profiles we have coming in each week.
Okay. And so can you I know you gave a somewhat of an overview of the process, but are there different names for these tests? So like a DNA typing, for example.
I'm not sure what you're asking. You talk about as far as the database is concerned, or DNA generally?
No, DNA generally. How do we get to the DNA database?
Yes, so for DNA typing, that process starts with removing the DNA from the evidence that's been brought into the laboratory. Once that DNA is removed from the evidence, whether it's a blood stain or a semen stain or saliva stain, we can remove the DNA and isolate just certain areas of the DNA that we're looking at. And then we can make more copies of those areas of DNA so that our instruments can then see that DNA. It's through a process that we call capillary electrophoresis, and it generates a graph that looks almost like an EKG, if you've ever seen one of those at the doctor's, with peaks and valleys on a graph. And each of those peaks are given a number. That number is what is then the DNA type. And when we look at all of those peaks, that becomes the DNA profile. And again, that's just a series of numbers. And so the person who is assigned to that particular case will generate that DNA profile. And if that DNA profile meets those criteria, those state and federal laws to be entered into the DNA database, they will provide that DNA profile so that myself or my assistant can then enter that into the database. And at that point, then it can be searched.
And so, did you have an occasion to do a report or issue a report on a victim, Ms. Cambria Herring?
Yes, I did.
And I'm approaching you with what has been previously marked and shown to Defense Counsel as States Exhibit 15 and 15A. Could you take a look at those and let me know if you recognize them?
Yes, I recognize these as official GBI reports. They bear a specific case number that is unique for the evidence involving Ms. Herring. These reports also bear my signature.
And are they fair and accurate, or States Exhibit 15? Is it a fair and accurate depiction of what it purports to be?
Yes.
Any alterations or deletions that you see?
No.
Your Honor, state moves to enter into evidence States Exhibit 15 and 15A.
Ms. Feely, any objection pursuant to our discussion outside the presence of the jury to the admission of 15 and 15A? All right, they're admitted.
Thank you. Okay, so let's talk about this report. Do you see a report date?
The report date is October 22nd, 2018.
And is that when this report was issued
Yes.
and made public to the DA's office?
Yes, yes. All of our reports are reviewed by second person. So that's the date that it's reviewed by the second person. Excuse me.
So what type of service was requested for this report?
Again, this is the type of report that we would generate when we have a match using our DNA database system. And so then we generate this report to give this information back to any of the submitting law enforcement agencies that have evidence involved.
And I know you mentioned that there's a DOFS number. Can you tell me that DOFS number?
Yes, our DOFS case number is 2016-10344649.
And was evidence received in this case?
Yes, the evidence that was previously worked were the items from the sexual assault evidence collection kit from Ms. Herring. And then the DNA profiles that were entered into the database were from item 1B, vaginal cervical swabs.
I'm approaching you with what has been previously marked entry State Exhibit 9. Do you recognize States Exhibit 9?
Yes, I can recognize this based on the barcode that is attached. This unique barcode also bears the same DOFS case number, as well as I recognize the initials of the individuals that have worked on this and then signed the seals, the red and green seals that you see on the item.
Okay. And let's talk about those red and green seals. So I know on your report, it indicates that the evidence or item 001, it indicates it was received, secured, but lack a proper seal. Can you tell us about that?
Yes, so when evidence is brought into the crime laboratory, our first person, what we call an evidence receiving technician, will examine the item to ensure that it has been properly sealed. That way we know exactly what we're getting is what the officer intended to bring, and there's nothing extra been added to the packaging, and that there's been no damage done to it so that we know we can complete our testing. If there's any issues, they will halt at that time and then contact the submitting officer to state there's a problem, we need to correct this. If it's something that we feel that we can rectify ourselves, we will. And so I know this based on this green tape that you see affixed on the bottom. We only use the green tape when we are correcting what we consider to be a potential problem. And in this case, there was a small tear in the bottom. And this kit contains multiple items that could have probably poked through the paper's not that thick. Or maybe there was something else that was leaning next to it that made a tear in that. So this tape was placed over the top by the person who noticed the tear. They would have initialed it, which they did on the bottom. And then it goes into the evidence description so that everybody who gets the report understands that we did see something and we rectified it.
And so inside of that sexual assault kit, because I know that you said that there was a tear or a puncture of sort. Inside of that sexual assault kit, I know that you said that there was a vaginal cervical swab. Is that just inside of that envelope or is it inside of something else in the envelope?
No, it is standard practice that all of these sexual assault kits have individual envelopes inside of those. And as a sexual assault evidence collection kit is taken from someone who presents at a hospital or facility, as their body is examined, different types of evidence is collected, and each of those different items will be sealed in separate envelopes. So like I mentioned, there being vaginal cervical swabs, and I have to make the assumption there's multiple items in this based on the size that it is. There would be multiple envelopes inside of this, one particular kit, and each of those would be in separate sealed envelopes.
And so the whole, would that affect the multiple envelopes inside of there? Would you be able to open up the multiple envelopes from that small hole?
No, looking at the photograph that was taken of the hole before the tape was applied, it was maybe a 2-inch tear. The envelopes that inside of there are a little bit larger. They would not have been able to fall out. If any of the envelopes inside of the packaging had looked like they sustained damage, then again, we would have halted and we would have taken additional steps to rectify that situation, which would have included notifying the submitting agency.
Thank you. Okay, let's go back to your report and talking about the conclusions, the results and conclusions of your report. Can you explain that section of your report?
Yes. So on our official report, we list, other things such as the submitting agency and the list of evidence. And then under our results and conclusions is where we then state the purpose for this report. And this report was to provide the information about the matches that had been obtained through the DNA database.
Okay. And what did the match indicate?
So the evidence in this particular case and the evidence from Ms. Herring, that DNA profile matched to another case also from East Point Police Department.
Okay, and that other case from East Point Police Department, can you give me that DOFS number?
Yes, that DOFS case number was 2006-1027-375.
And I'm now approaching you with State's Exhibit 27 and 27A. And 27A is the sticker for the.
Oh, okay.
Do you see that same DOFS number on 27A?
Yes.
Or 27, excuse me.
Yes, on 27, it does bear the same DOFS case number. And then I also recognize, again, some red evidence tape as well as from individuals that have worked at the crime lab.
And so those two cases were linked. And did it have a match to anyone?
Yes. Also, in addition to the match to the other case, it also matched to an individual. And so that name was provided in the report as well as, I'm not sure about the first name, but it's J.A.I. Scott Williams.
And prior to this date, so the October 22nd, 2018, did the GBI issue any information regarding a DNA match for Ms. Herring?
Not that I'm aware of. I believe this was the first matches that we got because the evidence had just been entered into the database.
And I know that you talked about how the swabbing was tested. Was the swab fully consumed in that testing?
No, it is our practice not to consume all of the evidence if at all possible, in case there is additional testing that needs to be done later. And so by the notes, I can see that there were 2 swabs in the envelope marked vaginal cervical swabs, and only half of each of those swabs were taken for the DNA testing that was performed.
And as it relates to the process, is there a way that this process is verified and that the matches are accurate?
Yes, again, like I mentioned before, all of our reports are reviewed by a second person. So all of the everything from the data all the way through to a match report, everything is reviewed by a second trained scientist.
And was that done in this case as well?
Yes, it was.
And was this the last step of testing?
No, as it's indicated on the bottom of our report, this is not the last part of testing that we have the ability to do on this case. The last statement on our report says that this information on these matches is just intended to be an investigative lead, and it's up to the submitting officers to then determine if they need additional testing. And since we have a person that we believe it matches, we're now asking for a new reference sample to be collected from that person and submitted to the crime lab. This is just an additional check for us to ensure that this person's name that we have linked to the database, that their DNA really is the matching DNA. So it's an additional process where a new fresh sample from this person is collected from their body, from their mouth, submitted to the laboratory, and it's compared back to the DNA profile from the evidence.
Okay. And was that done in this case as well?
Yes, it was.
And the person that did that match or confirmation, was that Mr. Ronald Smith?
Yes, yes. Ronald is one of my direct reports.
One moment. Did you have any other involvement with this case?
There is a related report. When we issue a report stating that one case matches another, we do issue that report under that second case number as well. So there is an additional report under the 2006 DOFS case number.
And that is Miss Lucinda Jones's case as a victim, right?
That is correct.
Nothing further, thank you. Do you need any?
Ms. Feely, do you have questions for Ms. Fowler?
Yes, thank you. Ms. Fowler, you spoke already about the item being received by your office lacking a proper seal. Is that right?
It appeared to be damaged.
And can you tell the jury why the GBI Division of Forensic Sciences is so strict about these protocols, please?
We are an accredited laboratory, and so we must follow national guidelines on how we operate. And that is one of the guidelines that we have in place, is to ensure the integrity of the evidence coming in, so that then we have some faith in our testing and our results to know that what came in is exactly what was intended to be submitted to us.
And the GBI doesn't have any control over East Point Police Department, right?
No.
Thank you. And more questions, John?
Any redirect?
Yes, Your Honor. And would this, Ms. Fowler, would this have been tested, States Exhibit, States Exhibit 9, would it have been tested if it did not match your standard, the GBI standard?
That is correct. We would not have tested it if we had believed that there had been any damage actually done to the evidence within that kit.
Thank you.
Jurors, questions for Ms. Fowler? Okay, yes, all right. You, sir? Counsel, need to talk with you for a second. Ms. Fowler, can you talk to the jury, please, about the notion of false positives in DNA analysis? Saying there's a match and it turns out that it wasn't a match. And by that, I don't mean someone did a sloppy job, but hey, these match and oh, how it would turn out. But it's Fred Smith who did it and not Jane Robbins. So they're not identical twins.
Okay. So in our field, we do hear false positives. It's really very difficult for us to have something such as a false positive with DNA. So I mentioned about how a DNA profile is a series of numbers. When we're looking at these matches, either through the DNA database or if it's just someone's sexual assault evidence to their known reference sample, our DNA analyst will go area by area through that DNA profile, and they will ensure that those numbers are the same. So they will make sure that both DNA profiles are the same DNA profile. Now, we may have some difficulties with doing this testing if we have situations that maybe there is a mixture of DNA from multiple people. And if there's multiple people involved, then we may not be able to make a clear and conclusive decision that yes, these DNA profiles match. But I don't know of a situation in which we've given one name and then it turns out that no, actually the DNA is somebody else. Because again, we're looking for these DNA profiles to be the same.
Ms. Robinson, any follow-up to that?
Yes, Your Honor, thank you. And Ms. Fowler, did you have multiple people involved in this case, other than the victim and Mr. Jai Williams?
Those are the only two individuals I'm aware of as far as for the DNA data that I looked at for the match.
And going back to the confirmation swabs, is that why that's so important?
Yes, again, it's just an additional step. So not only did the person that was in the database match, but now this new reference sample from this person also matched the evidence.
Thank you.
Ms. Feely? All right, Ms. Fowler, thank you for your time. Appreciate it. Ms. Reimer, state's next witness.
Your Honor, the state rests.
All right. Ladies and gentlemen, we have reached a critical point in these proceedings. You're going to get a break now because I need to talk about some things with the lawyers and we'll figure out what's happening after that. It is not time to begin your deliberations. It is never time to do outside research. So go back into the jury room, enjoy the snacks, the hallway, etc. How are the restrooms? Are they working today? Or have you not checked on them? I'm seeing some thumbs up. Good. All right. We will get you back out here as soon as we can. It may be a slightly longer break than usual, but that's what happens when we have this transition. Thank you.
All right, the jurors.
Okay, let's start with the defense. Any motions from the defense?
Yes, Your Honor, we are moving for a directed verdict on counts 2 and 3. We do understand the state of the law currently as it relates to the statute of limitations in DNA cases. However, we still want a record of the fact that the state in their indictment cite OCGA 17-3-2. And Mr. Williams became known on October 22nd, 2018, which is past the 4-year limitation if this wasn't a DNA case, for this to have been, this prosecution to have been brought. So we're asking for a directed verdict on counts 2 and 3.
Okay, I think I follow that. Your argument is not that 2018 is 4 years past the date of offense, but that 4 years passed from 2018 for Mr. Williams was charged with aggravated sodomy and kidnapping, both of which have a 4-year statute of limitation.
Right, and for the record, the indictment, well, this is a re-indictment, was April 20.
It was only like 2 weeks later,
Okay.
and so it's they're both April of 24. They're both outside that 4-year window if the 4-year window applied.
That's right.
Okay, so your motion for directed verdict is, I don't mean this in any way to diminish it, but it's purely procedural. It would be there's a bar to prosecuting Mr. Williams on counts 2 and 3. It's not the evidence was insufficient. Okay, understood. From the state, a response?
Yes, Your Honor. The state's argument is at 17-3-2, sorry, -3-2, periods excluded. 2, the person committing the crime is unknown, or the crime is unknown triggers then 17-3-1, D, and in this case, 2 and 5, which is kidnapping and aggravated sodomy. Therefore, the prosecution can begin at any time when the person becomes known via DNA, which is what we have in this case. In addition, the state would just point to OCGA 17-7-113 that the deficiencies in the indictment need to be brought before trial. It seems like this is a way to show that there's a problem with the indictment after trial's already begun.
Okay, I didn't hear it as a problem with the indictment. I heard it as the state hasn't proven that its prosecution of counts 2 and 3 was brought within the statutory period. I don't think it's a winning argument because, and Ms. Feely acknowledged it up front that, hey, the way 17-3-1 D is written, there's probably not a legal leg to stand on, but she's preserving that claim. But it's not that the indictment is deficient. It's that if you do the math, this indictment was brought more than 4 years after the date the state acknowledges Mr. Williams' identity was known as the alleged perpetrator, which is October 2018. If you fast forward 4 years, that's October 2022. I think what saves the state, both in terms of the motion and the case continuing on, is that the language, if inartful in invoking 17-3-2, because I don't think it needed to, also flags the DNA being used to establish the identity, which even though there's no reference to 17-3-1D, that's the law, and that says at any time. And we had this discussion yesterday, and there may be more when we talk again about the jury charge. But I do find that the state has presented evidence that gets to the jury, either the question of was this timely brought, because it was brought at any time, or actually just keeps from the jury the question of was it timely brought. And we'll cross that bridge when we talk more about the jury charge. Regardless, it's not a basis to grant a directed verdict as to counts 2 and 3, but the argument is preserved. Anything else, Ms. Feely or Ms. Wood, from the defense before I talk with Mr. Williams?
Mr. Williams needs a ruling on whether the court's going to allow the jail call in because, and that's part of our argument of why it should come out.
Okay.
And it is because it's affecting his decision whether to testify or not, and therefore not allowing him to have a fair trial is our argument because he was of one mind yesterday. Now we've explained to him the content of the jail calls and what that means for him on cross-examination. And so if the court does allow that, and again, it was clearly for the DA's office to use in this prosecution. It was not for jail safety or anything like that. So we're asking the court to exclude it.
Well, give me 1 second. I didn't get a chance to look at the case you cited just because things went by quickly. But elaborate for me, please, what you mean that something was clearly for the DA's office as opposed to jail safety. And the phone call wasn't for anyone other than it was Mr. Williams talking to his mom. The purpose of the call was for them to talk. The existence of the recording system is ostensibly for jail safety. Even in the middle of a trial, a defendant could say, hey, the bus that's carrying me to the courthouse leaves at 6 a.m. There'll be 2 vans in front, 1 van behind. If you can take out the van behind at the corner of Smith and Wesson, you might be able to get me from the bus that has me on it. There'll be 2 guards, neither is armed. That phone call might be fascinating to the state. They might want to use it in this trial, but surely the reasons that authorize the jail to violate one's privacy rights, and that's the wrong term to use, the reason, because there's this lowered expectation of privacy when someone's incarcerated, the policy reasons that have prompted courts to say that an inmate doesn't enjoy the same privacy rights in a phone call that you might, if you were calling a friend from your home or on your cell phone, have to do with maintaining safety and security, et cetera. And there's not a filter that's applied to say, a retroactive filter to say, oh, but that call, which was recorded as announced on the phone system before Mr. Williams calls his mother or receives a call from his mother, they don't, then it doesn't become a more protected call because Mr. Williams didn't talk about how his mom could get him off the jail bus and take him to Costa Rica so he couldn't be prosecuted.
Sure. So one thing that he does discuss is the 2015 allegation that is not coming in. And so we have established that that is not going to be a part of this trial. So at the very least, we would need that redacted.
What's the 2015 allegation? Is that the Tennessee case? I don't know what the 2015 allegation is.
I don't know very much about it either, but
It's a case, Your Honor, in which the state dismissed some of the charges and not all of the charges. And some of the charges that were dismissed were involving another victim of Mr. Williams.
A sexual assault victim?
Yes, Your Honor.
Okay. I'm going to hear from the state in a minute, but Mr. Williams speaks on a recorded line at his own peril. Let's say he said in the call, man, I'm glad this isn't the case about the time when I shot that person in the head and killed him. I don't know that that doesn't come in if that's what he's talking about. Maybe it doesn't come in because it's not relevant to this case. Certainly if Mr. Williams testifies and his character and credibility come into play, that broadens the scope of what is relevant and not, which is why I'm sure you want a ruling on whether the call comes in. But tell me why you think Mr. Williams discussing with his mother, not just any case, but a case involving sexual assault, but is not this case, meaning either Ms. Jones or Ms. Herring, why that wouldn't come in.
he also discusses stuff that's attorney-client privilege, but I think it goes back to the equal protection due process of he's an inmate. He can't talk to his family any other way unless we were to get some more deputies in here and close the courtroom off or something like that. So we just want him treated as a non-inmate
Okay,
in that regard.
but he is an inmate and in theory, mom could go to the jail during visiting hours. Those may not exist practically while someone's in trial because visiting hours may be 9 to 5. And of course, Mr. Williams is here. But I'm not aware of an exception that's been carved out where jail calls, although recorded, remain covered by the broader right to privacy that a non-inmate enjoys just because that inmate happens to be in trial. And talk to me a little bit about the attorney-client privilege. How is it privilege if Mr. Williams is telling his mom, hey, my lawyer told me X? Doesn't that destroy the privilege?
There's a good bit of trial strategy discussed. And so that goes back to the Davis case where it says, this is actually a search and not a recorded phone call, for privacy implications are the same. And it said, a search that is not initiated for legitimate prison purposes, but instead is instigated by the state for the purposes of bolstering the prosecution's case against a pretrial detainee, should be protected from unreasonable use like that. And I think if we knew what portion they intend to use, but they may not know that either at this point, maybe we could tailor our argument a little bit better, but that's our position for keeping it out. This was clearly to use in this trial.
Okay. Well, it's a fair point that we should figure out what might be used. I'm going to continue to push back on this notion that something was done for use in this trial, unless you've got evidence that the only time Mr. Williams's phone calls to anyone other than you or Ms. Wood were recorded were just during the trial. My understanding is that you type in your Securus number, your call is recorded, whether you're in trial, out of trial, you've been convicted, you haven't been convicted. If you use the Securus, assuming it's still Securus phone system, your calls are recorded. With the exception of there's some code you can put in, or maybe it's the number you dial. And if that is your lawyer's number, then that's not recorded. We're not in that space. This isn't the lawyer he was talking to. But do you have any reason to believe that this was the only call of his that was ever recorded? So it would be more akin to the case you're citing, where maybe the DA's office ginned up a reason to search someone's cell in the middle of trial because they had a hunch that this could help their trial.
I think it really infringes on the Fourth Amendment to have a prosecutor's office listen to his calls during a trial where he's facing life plus. And for him not to be able to have any privacy at all with, it relates to his circle of concern in this matter. I mean, he frankly was quite upset when we told him that his call to his mother, the evening after trial was recorded. And I think it is, just because you can doesn't mean you should.
I got it. I understand the can and should, but the law is the law. And it's not true that just because I can follow the precedents of the higher courts, that I don't have to. So I'm bound by that. And you don't need to put your client on the stand, but I guess part of what is eluding me is why Mr. Williams reasonably would have thought his jail calls would be treated differently now that he's been in jail for a long time. And I find it remarkable if what you're saying is he had no idea his calls were recorded, but you haven't said that. What you said is he seemed surprised that this call was recorded. And I don't understand what's different about this call. I appreciate it's during the trial, but there are no signs on the walls at the jail or on the recording that said, oh, but by the way, if you enter a second code that says you're on trial right now, we won't record it. In other words, why did he have any expectation, reasonable expectation, that this one call would be treated differently than every other call he's made to someone who's not his lawyer?
Sure. So the case that I hope the court will read, the Davis case, or at least portion of that before making a ruling, that there was also a situation where there was mail and it was open to figure out how to classify the mail, and there was something incriminating in it. And the court distinguishes there that was not instigated for prosecutorial purposes like this one was.
Okay. You didn't answer my question though. Any reason I should look to as to why Mr. Williams could reasonably think one phone call out of the hundreds he's probably made since he's been in custody to non-lawyers would be protected? I'm not following at all how he could be surprised that this one was recorded and thus available to law enforcement, to include the district attorney's office. And you don't need to answer it if you, but.
To my knowledge, this is the first time it's ever been turned over.
Okay. I don't think that's how the system works, that something's turned over as opposed to the state has access to it. In the same way, this pipeline that the defense likes to use, say, wait a minute, if the sheriff had it in his custody, the state had it in theirs for discovery purposes. It's actually a two-way pipeline. And so my understanding from testimony in other proceedings is that there are people who have been trained and have been given access in the district attorney's office to the Securus system, so that they can check on accounts. But I will look at Davis. Before I do that, Ms. Reimer or Ms. Robinson, I don't know who the phone call person is. How long is the call and what portions was the state planning on using?
I can tell you how long it is. One moment. 11 minutes and 26 seconds is how long the call is. It also, depending on what, if anything, comes out in testimony, if there is testimony, whether or not it would be used. I also have not had an opportunity to read the Davis case as we've been presenting evidence. But I find the argument that he's surprised this call was recorded not reasonable, because the inmates are notified when they make a call that they're being recorded and they can be used for prosecution purposes. In fact, my recollection of the call is that at one point he says, they know the call is being recorded, that they're listening, notifying to the fact that they know the calls are being recorded.
You're saying during his conversation with his mother, one of the two of them says, hey, remember, this is being recorded? Or you're saying that robot voice pops up?
There's a mention of it by one of the call. I believe it's Mr. Williams himself that says, just watch it. But they listen, or I don't know the exact verbiage, but it stood out to me this morning when I listened to it.
Okay. Are there parts of the call that you believe aren't relevant? There's really not a conceivable way Mr. Williams's testimony could go where they'd be relevant. Does that question make sense?
It does. I would have to break the call down bit by bit. We received the call this morning because the call was made last night, and I turned it over immediately to defense.
What in the call is something what's an example of something you'd use if Mr. Williams testifies?
Talking about the other cases and the victims in the case, and just how they know each other.
How the victims know each other?
Yes, that all three victims know each other. And sorry. And right, and the GBI is out to as there's problems with the GBI, and we're not supposed to be using certain cases or certain things as part of the prosecution in this case.
GBI planted his.
And that GBI has planted his DNA.
Okay. You're saying that Mr. Williams tells his mother, Ms. Jones and Ms. Herring know each other?
Yes, Ms. Jones, Ms. Herring, and there's a third person he refers to.
Okay. Is it your understanding that they know each other?
They have no idea who each other are.
All right. So, Ms. Reimer, you're in a bit of a pickle because we're not going to take a real long break. I need to look at Davis real briefly. I happen to be familiar with case law about the admissibility of, it's not the admissibility because it's two tests. One is, could it be used at all or should it be suppressed, the phone call? And then, of course, it has to be relevant, et cetera. But the law about suppressibility or non-suppressibility of jail calls is not particularly favorable for Mr. Williams. But I'll read Davis, which does not involve a phone call, as Ms. Feely said. But I will look at that and refresh my recollection as to the cases that pretty uniformly say, if you're an inmate and you're using a system that tells you the calls are recorded, if it's not a call with your lawyer, the state basically has that call. And it sounds like Ms. Feely and Ms. Wood, if the ruling is that call can be used, Mr. Williams might have a different perspective on whether he's going to testify.
Correct, Judge. And I was unable to actually play the call for him, given the fact that he was not up when I got here today. So if I may, during the break, just step back and play it for him, I would appreciate that opportunity.
Okay. Yes, we should do that. And whether it's you guys stay here and the state leaves the room, how long is the state's closing? Ballpark. I won't hold you to it, other than I'll make you stop if you exceed whatever number you tell me.
Sounds like you're being held to it, Judge.
No, I'm just working through whether we should just send the jury home now, because we need to work through this. Mr. Williams and Ms. Wood and Ms. Feely need to hear the call together.
Right.
I don't need to hear it so much, although I may need to ultimately, depending on how I rule. I want to look at Davis and just have some case law ready to put on the record that I'll be relying on my ruling, whatever my ruling is. I need to make that ruling, and then Mr. Williams and I need to talk about whether he's going to testify. If he is going to testify, that's what we could fill the rest of the day with. I don't know that we'd finish closings today, and that's why I don't want to start closing. I prefer not to start closings and then have some of them spill over into the next day. In particular, if all that's left is the state's rebuttal, I'm sure the state would love that, but it just, the defense would say, why can't we do it all at once? Which is why I'm asking how long you think closing will be, both parts, if you're doing both parts.
Probably in total an hour and a half, an hour and a half.
Okay. And any sense of the defense closing?
I don't think it'll be more than an hour, Judge.
Okay. All right. I think it will work better if we send the jurors home and let them know they need to be back at 10 tomorrow to start with whatever we're going to start with. What we'll start with is me asking the defense to call their first witness. We'll know before then what that's going to be, and we'll work through this phone call situation. Do you have any objection to that approach?
No, Your Honor.
Okay, and Ms. Reimer, if Mr. Williams chooses to testify, I guess you don't know whether you're going to have rebuttal. You'll need to hear what it is he says.
Correct.
Okay. You'd need to have rebuttal witnesses ready. We wouldn't say, oh, we'll then move to Friday for rebuttal witnesses. So I guess your wheels will need to be spinning as to what rebuttal would look like. Okay. Ms. Wood, do you have any objection to sending the jurors home?
No, Judge.
Okay. Then why don't we bring them in, and then we're going to take a long break so Ms. Reimer can take care of her situation, and we'll figure out when we're reconvening. But when we reconvene, we'll get closure on the phone call, and I'll talk with Mr. Williams about whether he's going to testify. You can bring the jurors in, please.
All right, so good. Just the president accounted for.
Thank you, Deputy Gordon. Everyone else can be seated. So ladies and gentlemen, we need to break for the day. A couple things came up while you were back in the jury room that the lawyers and Mr. Williams and I need to work through before I can turn to Ms. Wood to ask Ms. Wood to call the first witness for the defense. It won't take all between now and 6 o'clock for us to work through it, but in asking the lawyers what they need to do, and actually some work I need to do back in chambers in connection with what came up, by the time we got you out here, whatever we were going to start would be interrupted by the end of the day. And the lawyers asked, I think it's a fair request, could we not chop it in that way? It could be, we're not going to chop it up that way. So we're going to start at 10 tomorrow with me asking Ms. Wood to call her first witness. Ms. Wood may say the defense rests. because there's no burden on the defense, or she may start calling witnesses. If the defense rests, because of the work that we are doing this afternoon, while you go home early, we'll be able to transition immediately into closing arguments. If we don't do what we need to do right now, then once the defense rests, there'd be another big break, et cetera. So I apologize that things are coming at you a little choppy, but the state has rested. So we've reached that milestone. And we will find out at 10 in the morning if the defense, which has a right to present evidence, but no obligation to, is going to be presenting any evidence. And we will take it from there. You are going to get back to work or home or whatever you wish to do. The same restrictions apply, even though the state has rested. And you may receive no more evidence. If the defense doesn't put on any witnesses, then the evidence is closed. You may not supplement that by doing any outside research. So don't look anything up. Still don't talk with people about the case because they'll try to supplement it for you by sharing with you their helpful but not relevant insights as to what you have been working on. And we'll pick it up from there. So leave your notepads in there. Any logistical questions from anyone? The jury room will be open early again. If your work, commute, sleep patterns are such that you want to get here before 10, you're free to do that. When does the shuttle stop running so regularly in the morning?
Sure.
He's not sure. That's helpful.
Probably noon.
Oh, I thought maybe like 9 was the last every 15-minute one.
I think it's 10 o'clock.
10 o'clock. Okay, so they run frequent. Thank you. They didn't know you could talk. So you may be good if you sail in there at 9:40. There may be a 9:45 one that would get you here. I know later on they only run every half hour, and so if you showed up at 9:35, not only would you be waiting for 25 minutes, but you wouldn't make it here on time. So do your best to be here by 10, and we'll get rolling as soon as we can after that. Any logistical questions? No? Thank you for your time.
Call out the jury.
All right, you guys can stand or sit, whatever you want to do. We're going to wrap up temporarily in just a second. When we reconvene, we're going to talk about the jail call. We need to, I think, wrap up our charge conference or revisit a few things. I'll engage with Mr. Williams about whether he wants to testify. Is there anything, and I'll have a verdict form so that we really will have covered everything. Ms. Reimer, anything else from the state?
No, Your Honor.
Okay. Ms. Wood, anything else from the defense?
No, Judge.
All right. So let's aim to be back here around 4:15. That'll give people time to do what they need to do, listen to the call, et cetera. Could someone email me the call? Is it a huge file? It shouldn't be if it's just
It's
audio.
emailable, yeah.
Okay, if you'd email me the call, I may listen to it if I have time, but I'll certainly going to do a little legal research, and then we'll aim to be back here at 4:15.
And
Okay.
Judge, just a question. I know that you're live on YouTube, but I believe that the jury boxes may be showing. Is that a problem?
It's the last two.
Like the last
So
one
a
I
couple
looked at
things.
this screen.
One, it's not because anyone could be in here and see that. That got moved for drug court. We need to angle it back a little bit. But what I try to do in shifting to the podium is when they're streaming out, the witness camera tends to pick people up.
Okay.
But I'll have Deputy Gordon adjust that. Our drug court participants were standing at the podium and the people at Hope Hall couldn't see them. And so it got adjusted and it caught that corner. But for about 99% of the time that the jurors are in here, it's this camera that's running and you can't see any jurors that way. But thank you for flagging that. Anything else? Okay, Ms. Wood, anything else?
No, Judge.
All right, 4:15-ish.
Joe,
All right, can we bring Mr. Williams out, please? It is better. I don't know, I'd say a lot better, but it's definitely better. We played a video and there was no lag on anything. All of the screens are touch screens. So if you're at the podium asking a witness a question, you could circle something and say, what is this inside the circle? Oh, that's the doorknob of the door, or that's a bullet hole. So that's nice. There are going to be more screens for people to see stuff. Trying to think what else. There was mostly the lag not being there, but they're going to test it out actually with a trial tomorrow. Judge Emerson's trial will go back into 1D. And so with actual body cam footage and whatnot, they'll do it.
No.
Trying to think what else.
So the touch screen, you have to find the pencil.
Same thing. You just touch it anywhere and then a little pencil in the corner and then you can draw on it.
Nice.
Yep. All right. Let's get on the record, please. We are back in State versus Williams. It's a little after 4:30 on Wednesday, and we need to work through what to do about the recording of a phone call that Mr. Williams made to his mother. Sounds like yesterday, last night. And after we work through that, Mr. Williams and I need to talk about whether he's going to testify and then anything else we need to work through. So, Ms. Feely, is there more that you want to get into the record about the call or the law surrounding the, not the admissibility, but the suppressibility or non-suppressibility of jail calls?
No, Mayor, that was all I had. In the event that it comes in, we'll discuss amongst ourselves any redactions.
Okay. Ms. Reimer or Ms. Robinson, what do you want to share about the suppressibility or non-suppressibility of jail calls and attorney-client privilege? Those were two concerns that Ms. Feely raised in connection with the call.
Yeah, sure. First, I want to just correct the record. I re-listened to the call and I misheard this specific call about Mr. Williams correcting his mom to stop talking. It was, don't say too much, the call's ending. So I just want to make sure the record's clear that that's actually not what was said.
Got it. I listened to the first 30 seconds just to make sure it was a standard Securus call, and unmistakably on the recording that you provided me is a recording of a female voice saying, this is being recorded.
Yes.
So that standard needed to be there. If that announcement isn't made on the call, it's a different analysis we need to go through. You might need to call a witness before you can necessarily play it for someone who is one of the speakers of the call. But that was definitely there. But I appreciate you flagging that you don't believe in the call at any point. Either Mr. Williams or his mother says, wait, shh, gotta be careful because people could be listening to this.
Not in this call, Your Honor. And I did listen to it as well. I believe it said minute 113, where it said the call will be recorded and subject to monitoring at any time.
Yep. Let me stop you for 1 second. Ms. Feely, did you have a chance to play the call for Mr. Williams?
This one did.
Okay, one of you did.
Yes.
Excellent, thank you. Ms. Reimer.
I guess I'll first start with the attorney-client privilege. The attorney-client privilege exists between the client and the attorney, not a third party, and this is the client communicating with third party. So I would argue that there is absolutely no attorney-client privilege between the defendant and his mother, and that argument should fail for that reason. It's well settled law that there is no reasonable expectation of privacy that an inmate enjoys in a monitored and recorded jail call. The sheriff has a legitimate interest in monitoring and recording it. It's not a sphere that society deems reasonable as a reasonable expectation of privacy, and they are also notified that they are being recorded and monitored. And they still choose, they've still chosen to make the statements that were made. So the state would argue that there's Keller v. State, which is 308 GA 492, which cites to Preston v. State. It's 282 Georgia 210. Preston specifically dealt with an inmate call with his mother, and it just goes to that there's no reasonable expectation of privacy, and it should not be suppressed for those reasons.
Okay. So, first, as to the expectation of privacy, I was going to rely on Keller as well, but it's in the record. It's a 2020 case, so still very new from our Supreme Court, and it echoes the theme of multiple Georgia Supreme Court and Georgia Court of Appeals cases that there is not a reasonable expectation of privacy in a phone call that is recorded, made from a jail or a prison. Here we've got jail. It's a pretrial detainee, but the courts have made clear that that status of you've been convicted versus you haven't been convicted isn't the germane one. It is you are in a secure, as in a jail, a prison facility versus you are not. And it's that loss of liberty interest when you are being detained that carries with it a loss of a reasonable expectation of privacy of things you say and things you do while you're in custody, coupled with the fact that on the phone call, very audibly and intelligibly, it is announced that the call will be recorded and is subject to monitoring. There are sound public policy reasons for jail calls to be recorded. And I find that Mr. Williams did not have a reasonable expectation that the call he had with his mother last night would remain private. He might have been surprised that people cared about what he had to say, but gosh, during trial will be the last time you ought to get on the phone and talk about the trial strategies, et cetera, because in some respects, there'd be a heightened expectation that if ever the jail's gonna wanna know what I'm talking about, it's when I'm in trial and things might not be going well. And they'd be most concerned about a way to figure out how can I get out of the courtroom while I'm here and not stuck in jail, and the doors aren't locked, et cetera. So it was properly recorded and the state properly possesses it. The attorney-client privilege piece is separate because you still could have a conversation where maybe you don't have a reasonable expectation of privacy, but some type of privilege could attach to it. Although generally, if you are having a conversation in a public space or a space where you shouldn't expect that the communications are private, you risk waiving that privilege. But here, it's an even clearer waiver. And I rely on the case of Reed, R-E-I-D versus State, 306 Georgia 769, where a pretrial detainee named Ms. Reed called her mom from jail and on the phone talked to mom about trial strategy and things that she and her lawyer had been talking about. And the Supreme Court said that is not privileged because, of course, this is Ms. Reed talking to her mother, not Ms. Reed talking to her lawyer. So I'm not saying that what Mr. Williams may have said or his mother may have said about lawyer conversations or trial strategy are relevant, but they are not suppressible or excludable on the basis of attorney-client privilege. So I'm not suppressing or excluding the call. As I mentioned, I didn't listen to the substance of it. I just wanted to ensure for my purposes that recording, the beginning, that recorded statement was made about you should not assume that the government won't listen to this call, was made, and that statement was made, and yet Mr. Williams persisted in his conversation. So I'm not ruling about relevance, and as one of you mentioned, Ms. Feely or Ms. Wood, if it's reached the point where Mr. Williams testifies and there's a basis to admit the call, you all will have sorted out, are there parts of it that you want to object to on relevance grounds or 403 grounds where it's relevant, but it's the undue prejudice substantially outweighs the probative value. I will flag for you, as I thought about this more, I don't know that Mr. Williams talking about another alleged victim wouldn't be 413 evidence. And that shall be admitted for any purpose. It doesn't typically come through a defendant talking to his mom, but it could come from anywhere. And the fact that that case might have resulted in a reduction of charges or a dismissal or a plea doesn't have any bearing on whether it would come in as 413 evidence. Now, the door has to be open for that. And that's, I'm sure, a conversation you've been having with Mr. Williams. In other words, the state's rested and they can't play the call if the defense puts on no evidence because there's no rebuttal to a defense case that doesn't involve the affirmative presentation of evidence. So that's where I think we are. Is there anything more you want to get into the record, Ms. Feely, about the call? All right, so should the defense put up evidence, it's possible that it would be then appropriate for the call to come in, assuming it's relevant. I think that's where we are. Are there other things we need to talk about from the defense before Mr. Williams and I talk? Or do you need to talk to him now that I've ruled? Ms. Wood?
No, we covered, like.
The
both sides.
contingencies?
Yes.
Okay, I figured you would. Mr. Williams, it is time for you and me to talk about your decision about testifying. And I foreshadowed this yesterday during our charge conference or before our charge conference. Do you understand, sir, that you have the right to testify and that if you wish to testify, no one can prevent you from doing that? I need you to answer out loud so Ms. Rivers can hear you. Okay. Do you understand that in the same way, no one can compel you or force you to testify? Meaning if you don't want to testify, state can't call you. I can't say, come up here and testify. You have this absolute right to remain silent. Do you understand that? Do you understand that in just a moment, it is you who will be deciding on the record whether you're going to be testifying, not Ms. Wood, not Ms. Feely? Do you understand that if you choose not to testify, I'll be instructing the jury that they are not to consider that in any way, in particular in ways that are harmful to the defense? Do you understand that if you choose to testify, not only do you need to answer whatever questions Ms. Wood or Ms. Feely may have for you, but you'll be subject to cross-examination from Ms. Reimer or Ms. Robinson? Understanding all those things, Mr. Williams, do you want to testify in your case?
I would like to. I really would.
Okay, let me ask it differently. Do you intend to testify?
Yes, I do.
Okay. What we will do at 10-ish tomorrow when we get started is I'll ask Ms. Wood, and if that remains your perspective, she's going to say the defense calls, there may be other witnesses, but ultimately she'll say the defense calls Jai Williams, and then you'll be able to testify. I find that at this juncture, Mr. Williams is making his decision to testify with a complete understanding of his rights. But I'll add this, Mr. Williams, you are not committing yourself to testify. You have 5 and 12, 17 hours to change your mind. But when we resume at around 10 in the morning, what we'll be starting with is me asking Ms. Wood to call her first witness. And given that your lawyers didn't have a witness list, the only witness she'd be calling would be you. If she says no, the defense rests, that is, well, we'll probably have to revisit this just before we start because I'm not going to tell the jury to get out of the room. If the defense rests, we're going to turn straight to closing argument. So just know that before the jurors come in tomorrow morning, I'm going to ask you, without going through all those other questions, is it still your intention to testify? And if you say yes, that's exactly what will happen. If you change your mind and you say no, I don't tell the jurors, oh, he was going to testify and change his mind. I'll just go with that jury instruction that says a defendant is not obligated to testify. If he chooses not to testify, you may not consider that fact in any way during your deliberations.
I understand.
Sounds like you do. Ms. Wood, anything else in connection with that?
No, Your Honor.
All right. Let's talk about the jury charge. Okay, I've got it back up. I'm not gonna put it on the screen yet unless there's stuff we need to look at. Ms. Reimer, did you have other points you wanted to make in terms of what should be in or out of the jury charge?
No, I don't believe more than what was discussed yesterday, Your Honor.
Okay. Ms. Feely, you were gonna have a consult with the appellate unit. Anything to add to what we discussed before?
Unusually, they did not have much else to add, so I think we're good.
So we're good-ish. Are you requesting any charge about the statute of limitations? And if so, what does that look like? And I will share my screen, so we at least got that up. Come back.
I don't think we were requesting anything at this time related to that in terms of jury charge.
Okay, so your preference would be to, you can see on the screen now, and this, I didn't change it from yesterday. I had hoped to get to it, but I didn't. This was cobbled together with it's 15 years for rape and it's 4 for the others, but your preference would be to have no language in the jury charge about statute of limitations. Okay. Ms. Reimer, what is the state's perspective as to whether there should be language in the jury charge about statute of limitations?
We would just ask that the law, the 17-3-1D is read. So there's no confusion as to the years for the statute of limitations. It's the prosecution for the following offenses may be commenced at any time when DNA evidence is used to establish the identity of the accused. 2, 3. And then specifically 2 is kidnapping, 3 is rape.
I got you. So there would be a section on statute of limitations, but it is what you just said. It would basically include the language of 17-3-1D. But it would be a prosecution for rape, aggravated sodomy, or kidnapping can be commenced at any time when the identity of the accused is established through beyond a reasonable doubt. I don't know if I put that in there, but through DNA.
Yes, Your Honor, specifically because it's the law, and also that the calculation of any period during which evidence shows a person committing a crime is unknown, which is not the proper analysis, which we've established, that they can be confused that the 4 years began in 2018 rather than at any time.
But if I'm not talking to the jury at all about 4 years or 7 or 15, why do we talk to the jury about statute of limitations at all?
Because this is a cold case, Your Honor, and it was brought later. And specifically here in the statute of limitations, it says a prosecution for aggravated sodomy or kidnapping must begin within 4 years after the offense is committed. And it's in the indictment.
That's the law unless ... but the unless condition has been satisfied. And so the verdict form's not going to say anything about statute of limitations. It's just going to list the 3 offenses, guilty, not guilty. Unless the defense is going to be arguing something about it, I'm happy to say you may not, or else I'm going to give this jury charge. I'm just curious why we even inject that into the law that I give them.
Because it's been brought up in the indictment, it's charged in the indictment, and also there's been various juror questions about the statute of limitations.
Okay.
It's been made an issue in the trial.
And you think it would lay to rest what would frankly be unjustified concerns, because the law is that this particular prosecution for these 3 crimes could have been, based on how the identification was made, could have been brought at any time.
That's correct, Your Honor.
Okay. Ms. Feely, I think I will, and I'll share the language with you all in advance, but I think I will have, it's probably just 1 sentence, maybe 2, about statute of limitations that says in effect, when identification is established through DNA, a prosecution may be brought at any time, kind of full stop, not getting into 4 years or 7 or 15, nor offense specific, because all three are swept up in D.
Understood.
Okay, all right. And it sounds like your appellate team didn't have any other changes. So, then the one piece that I will revise the, statute of limitations part, share that with everyone. And then either defendant's choice not to testify is in or it's out. And I think we have our jury charge. Okay. Ms. Reimer, anything else from the state?
Just the verdict form.
Right,
Yeah.
I didn't end up doing that. I had to go look at this
Okay.
evidence presentation stuff in 1D.
Yes, Your Honor.
But it's gonna be pretty bland, 3 counts, guilty, not guilty. There's no lesser included or anything, but I will circulate it. That will be, I'll email it along with the final draft of the jury charge.
Thank you.
Yes, Your Honor. Thank you.
You should be ready to go with, if you're gonna open and close, with the opening part of your closing at 10 in the morning.
Yes, sure.
If Mr. Williams chooses not to testify, we're going straight into closings.
Understood.
Similarly, if Mr. Williams chooses to testify, you'll need to see where that takes the case. But sort of in real time, you'll need to be lining up rebuttal folks. I don't know how you do that, but we might bump into the lunch break and then you'd have a little more time to try to get witnesses here. All right, Ms. Wood, anything from the defense?
No, Judge, thank you.
All right. And we have closed for Mr. Williams tomorrow?
We will, Judge.
We will. Okay. And because we don't start till 10, you don't need to scramble to get them here now. It's 5. But if you can get them here 9:30-ish at the latest, then Deputy Gordon can get Mr. Williams dressed out so we can get rolling.
Thank you.
You're welcome. All right. So Mr. Williams, I will check in with you one last time when we start tomorrow about your intention, not just your desire, about testifying. Okay?
Yes, sir.
All right. Thank you, everyone.
Congrats.